Good morning and welcome to Becker's webinar on a multidisciplinary look at the force majeure clause in the age of COVID-19. Usually, hurricanes, floods, and other natural disasters are commonly found in these clauses, but rarely do you see any language concerning to pandemics. Today, we're going to take a broad look at the force majeure clause and discuss how it affects real estate, community associations, construction industries, and of course, litigation, because that's where it usually ends up, as well as what it takes to employ the force majeure defense, especially in these times of this pandemic where we're living under conditions that we've never seen before. My name is Jennifer Bales Drake. I'm a shareholder and vice chair of our P3 practice group. I practice in the area of commercial real estate, representing, I do large commercial transactions. I represent developers in creating condominiums and community associations. We have a wonderful panel of Becker attorneys here this morning that I'm going to let them each introduce themselves. I'm going to start with you, David.
Good morning. My name is David Blattner. I'm a shareholder at Becker. I practice in the real estate department. I do transactional law. I'm the contract guy. I put things together, well, as some of my colleagues here take things apart. I've been practicing for over 30 years in commercial and residential real estate, handling all types of transactions from acquisitions, development deals, sales, landlord-tenant, that's leasing work. And I work with all of my partners in putting deals together, representing, as I said, developers and landlords and tenants and investors and lenders as well. This clause, as you'll see, plays a role in all of our transactions that we deal with on a daily basis.
And he's also a new grandfather. Thank you, David.
Thanks, Jennifer.
Patrick.
Thanks, Jennifer. Good morning, everyone. My name's Patrick Howell. I'm here today representing Becker's Construction Law Practice Group. I'm board certified in construction law, and I've been practicing in this area of law for almost 20 years. I'm really looking forward to addressing any questions that may come up with special applicability to construction projects. Thank you.
Thank you, Patrick. And now to John, who is a litigator who usually tears mine and David's clauses apart, or he helps us when we run to him and say, how can we get out of this? John.
Good morning, John Polenberg. I'm a shareholder at Becker. As Jennifer mentioned, I'm the guy who you come to when you want to fight about something. And today we're going to talk about how you fight over the force majeure clause. So I'll leave it back to you, Jennifer.
Thank you. And last but definitely not least, Steve Mezer.
Good morning, everybody. Thank you, Jennifer. I'm a Becker shareholder in the Tampa office, practice the law with community associations. I'm board certified by the Florida Bar in condominium and planned development law, as well as real estate law. Been practicing over 30 years. We'll just leave it at that. And I'm happy to be on the panel.
All right, so let's get started. David, I have a question for you that's sort of basic. Can you give us an overall view of just how the force majeure clause works in leases and contracts?
Sure. Let me start by reading a very basic clause that you can find in contracts and leases. It's a simple one, but it's common, and many of you may have seen it in some of your documents. The clause is, the parties shall be excused from the prompt performance of their obligations hereunder if they are delayed by force majeure, which shall mean acts of God, labor disputes, material or labor shortages, restrictions by any governmental authority, civil riots, floods, or other causes beyond the parties' reasonable control. Now, this generally means that the parties are excused from prompt performance if they're delayed by a force majeure event. And as you can see, it gives a list of definitions. And in today's climate, in today's COVID climate, we're looking at three things. First, we're looking at restrictions by any governmental authority. Now, we all know that the government has basically shut us down. They've told us to stay home. They've told us we can't go out to work. So in a lease or a contract, has this government shutdown caused us not to be able to perform our obligations under the lease or contract? We're looking at things like the benchmarks that are in the lease or contract. Can the landlord deliver the lease premises on time due to these governmental restrictions? The landlord's build out, the tenant's improvements in a lease. Has the government restrictions, have these shutdowns caused us not to be able to reach our build outs? Those are the kinds of things we're looking at when we're talking about the government restrictions. Next thing we might be looking at are acts of God. Certainly, coronavirus might be arguably an act of God. I mean, it's no other thing. It's not a man-made act, but the act of God itself is not what's causing us to miss the benchmarks in a contract or a lease. The fact that we can't go to work and perform our obligations is not because we're sick, it's because some other factor has stopped us from performing under the obligation. So we're not going to generally look at the act of God provision in the force majeure clause as our excuse for not performing. The third thing we're going to look at are causes beyond the party's control under the lease. So there's a whole host of reasons that we can't perform under the contract or lease. One is a government restriction. Two are permits aren't being processed. There's not enough workers to be in the governmental office to process our permit applications. You can't get approvals if nobody's there. Three is banks just stop processing loan applications. So you might not be able to make a financing contingency. These are just some examples of reasons that you aren't going to be able to meet some of these benchmarks in your contracts, in your leases, that would allow you to start looking towards a force majeure clause for non-performance. And another thing that I wanted to point out is there's going to be supply chain distributions because of what's going on here. So this is another act that's beyond the parties to a contract or a lease that their control that might be a reason for looking towards the force majeure clause. But let me just say, it's not the illness, the pandemic itself that's causing you not to be able to perform. And I want to come back to that a little bit later in our discussion, because as you can see in this general force majeure clause, pandemics, illnesses, epidemics, health scares, not listed in this general list of force majeure events. And why is that? Because we've never experienced this before. 20 years ago, 19 years ago, terrorism wasn't a reason under the force majeure clause or under insurance policies for payment under an insurance policy or for under a force majeure clause for not performing. But then we had 9/11 and we all started to think differently. And COVID-19 is giving us a reason to think differently. Jen?
Thank you, David. Patrick, I'm going to ask you a little bit of more of just a use question here, or practical question. You do construction law. I'm a contractor, and several of my projects are falling behind because of delays and interruptions directly related to this pandemic. Not because they've shut my business down, not because of the pandemic, my workers are sick, but it is directly related to the pandemic. What can I do to protect myself?
Great question. Thanks, Jennifer. My advice is for a contractor in that position is to document. You need to make sure that you are documenting everything that's happening that's pushing your project behind. So if your foreman falls ill, immediately inform the owner and then document everything that you're legally able to document about his illness, any quarantine that he or she has put under, whether or not you're going to be dinged for the delays in the project will be directly related to whether you've properly documented what happened. Also, do everything in your power to find a way around the delay. That would be the advice that I would give a contractor or subcontractor in this position. And document what you're doing to find a way around the delay. So if one supply chain dries up, don't just throw your hands up and start binge watching your favorite show. Instead, make an effort to find a different supply chain. If your foreman falls ill, like in the example that I gave before, is there a superintendent that knows the project well enough to take over? If so, obtain the permission of the owner and make that switch. And once you do that, document that the owner has agreed to this. Remember, a judge or jury may later be second guessing what you did to keep the project going. So whatever you can do to paint a nice picture for them, do that.
Do you recommend interacting with the owner as you document, like document to them as well as your own records?
Absolutely. Make sure that that owner knows and understands that you are doing everything in your power to find a way around the delay, and also what your problem is. If your supply chain is having issues, you need to make sure that you let the owner know that so that they understand it. They may have an idea or a way around the delay. So work with them, and that's going to allow you to seek reimbursement later on for these delays.
Thank you. So, John, now we've talked about the force majeure clause itself. Let's say I'm still this contractor and my owner is just being obstinate, saying, I don't care, I'm not going to work with you. What does it take to employ a force majeure as a defense in a contract claim?
Thank you. The key word you use there is a defense. So the supposition in the question is that you're not going to perform your obligations under the contract, and you need an excuse that the court will recognize as a viable basis to escape the obligations that you're unable to perform. The points that David and Patrick made are great points, but it's going to start with what the clause actually says. The concept here is it impossible for you to perform whatever obligation it is that you owe under the contract based on whatever the force majeure event would be? In this case, the COVID-19 crisis. As David said, looking for the virus itself as a basis for not performing when you're not necessarily sick yourself and your staff is not sick is probably not going to be a basis to claim that it's impossible for you to perform your obligations under the contract. More to the point, it's going to be something that ties the COVID-19 crisis to a particular obligation under the contract that ties to something the government has done under this particular circumstance. So if you're a restaurant and they close down your dining room, what does that mean? If you are a supplier and you can no longer get your supplies because of certain restrictions on transportation based on the crisis, what does that mean? Those are what you have to evaluate when you read the contract, and every contract is going to be different, and every force majeure clause is going to say something different. But in the end, the touchstone inquiry is going to be, is it possible for you to perform? So in the example of a lease, the government orders that we've seen across the state of Florida and in other states is the restaurant can still operate and give takeout. So it's possible for the restaurant to perform. If you use David's advice and say, can I tie the order shutting down a portion of the square footage that I use in my dining room to inability to perform or impossibility to perform under the lease, it's going to be a hard argument because it's not impossible for you to perform. Your revenue may be reduced, but you need to be able to tie the obligation to something you can't do. So perhaps the way you deal with that is you use it against the landlord if you're the tenant, and we'll talk, I guess, later about if you're trying to defend against the force majeure clause. But if you're the tenant under that hypothetical, you're going to want to say the landlord can't perform his obligations because he can't give me all of the square footage that is promised to me under the lease. And there's usually in a lease, there's a provision that provides for quiet enjoyment. And there's also a use, if it's a commercial lease, that is going to be used for a particular purpose. So if you're a restaurant and the lease says it's an eat-in restaurant and that the landlord promises to give you quiet enjoyment for that purpose, and now the landlord can't do that, then perhaps you make the landlord deploy the force majeure clause, and then you, by saying you're in breach, and then he has to use the force, or she has to use the force majeure clause to defend against your claim of breach. There's lots of ways to look at it. It depends on how your contract is drafted.
Okay, thank you. Steve, if there's not a force majeure provision in a contract, are there possible defenses recognized by Florida courts where the defendant is asserting a force majeure type of event status as a defense?
Yeah, that's kind of an interesting proposition. Force majeure does not arrive in your contract by magic overnight. If it's not there, it's not there. So we have to look elsewhere for the defense. Florida recognizes both impossibility and impracticability. They're very similar, but making the performance impossible or near impossible would be the standards. And that's really what force majeure is in many respects, but there is available to an association, in my instance, a substitute for force majeure, and that would be that impossibility or impracticability. For example, we might have leasing restrictions and the governor of Florida has changed the leasing restrictions prohibiting short-term rentals. Well, the governor has interceded, making it impossible for those short-term rentals to occur, so we're not going to be approving those. Force majeure, normally we do see in most of our contracts, though. We'll see it in the restaurant contracts, all the things that John was referring to. In addition to that, condominium associations, homeowner associations will see force majeure in their cable television contracts, as an example. And there, we're looking at typically the provider saying it's impossible for us to provide you with the cable television service, so we want to be excused. We want to make sure that we recognize that it's a mutual excusing of performance so that we're not going to have to pay for it. We did have one of our clients has multiple 16-unit buildings. One of the buildings was struck by lightning, an act of God. We went to the cable television contract, and it was an old contract. It did not excuse performance by the association, and so we had to say, well, look, that's got to be mutual, so we don't pay for cable television when we no longer have 16 units in the condominium. So it's a case-by-case basis. If it's not there, you're looking at that impossibility, impracticability. So you do have defenses. You just have to work with David to make sure that you assert them properly.
All right. David, can I rely on a force majeure clause to avoid paying rent?
Well, nearly all force majeure provisions in leases specifically exclude the obligation to pay rent from that clause. In fact, the clause that I read earlier, I deleted that language when I read it. The clause that I read says the parties shall be excluded from the prompt performance of their obligations hereunder. And the language I didn't read said, other than the payment of money. So that means that a tenant or a buyer, if it was in a contract, can't argue that force majeure precludes the obligation to pay rent or to make a contract deposit or to finish a closing because of a force majeure event. And in the last 30 plus years, I can't recall a landlord drafted lease that didn't have this specific language in the force majeure clause. I think the case law, and John or Patrick can chime in here, I think the case law has been fairly consistent that force majeure does not excuse the obligation to pay rent. And that's why, but we still put this language in the force majeure clause just to be certain that that money obligations are not excused because of a force majeure event. So a tenant should not think that just because their revenue stream is down due to a force majeure event, they shouldn't be obligated to pay rent. Now, that also is not to say that because we're in this crisis situation, you shouldn't be approaching your landlord and asking for some relief. We have had countless situations, and I'm sure everybody on this webinar has had discussions, whether they're as a tenant or a landlord, a borrower or a lender, looking for rent abatement, rent deferment, mortgage abatement, mortgage payment forbearance due to this situation. COVID-19, coronavirus, is a unique situation where we're all working together to try and work out solutions to help each other deal with the crisis because of reduced income stream. I wouldn't say that the typical force majeure event, whether it's a hurricane or a fire or some other situation, people are going to be quite as cooperative because insurance usually steps in and allows people to come up with the proceeds to make the payment. This one is unique.
John, I've got a quick question for you tied to something David said. So what if your lease doesn't, because I agree most leases have the language that says that rent cannot be excused for force majeure. What if you have an inartful landlord drafted lease? Do you see any arguments in this pandemic that that tenants can use to not pay their rent?
It all depends on the facts, right? So you can, there's a series of hypotheticals we can construct that might give you a way to escape the rent obligations. For instance, separate from the one I mentioned earlier, where if you sue the landlord first, the landlord defends the breach for quiet enjoyment and use by using the force majeure clause, and then you counter that with saying, I'm going to set off on the amount of rent, which contemplates kind of what David was saying with his first remarks. But moving on from there, either in a lease or another contract, you can foresee a circumstance, let's say, for instance, if it's a commercial lease where the tenant is obligated to pay not just a base rent, but some share of revenues. The obligation to pay rent is directly tied to the share of revenues, and now you have an event either that's recognized under a force majeure or, as Steve mentioned, under the common law doctrine of commercial impracticability, where now that revenue sharing is not feasible given the COVID-19 crisis and the orders that the government has issued. So you can make a pretty decent argument that, yes, I have to pay the base rent, but during this period of shutdown, I don't have the obligation to pay a share of rent of revenues because it just doesn't, it's not what the parties contemplated. So I think there's ways that could arise without a revenue sharing type of situation in a lease. It would be hard because you would have to expect that courts are not going to look at contracts as a way to tie your obligations as a tenant to your financial performance under any circumstance as a general proposition.
And Jennifer, if I could jump in there, I've had this discussion with some commercial brokers on percentage rent, and I agree with John, because most leases, as you know, there's a break point before the revenue share, the percentage rent jumps in, and it would be beyond my comprehension but certainly somebody's going to make the argument where a landlord could jump in and argue that there's some kind of breach of lease because a tenant or some other contracting party didn't reach a break point where percentage rent or revenue sharing kicked in due to an event like this. I mean, we're just shut down, and that's where an impossibility argument is certainly going to kick in, where John would certainly argue that it was just impossible to perform. We're not making the sales. We're not making the sales. We have no customers. We can't we absolutely cannot perform. We cannot reach our goals where those revenue shares, those percentage rent obligations kick in. So I don't know that force majeure actually would apply there, or it's just an impossibility argument. John, Pat.
I'll let Pat take that one.
Well, yeah, you know, maybe so. The interesting thing is whether some false pretenses are being used. I had a client that their tenant came to them and asked for a change in their lease to address subleasing. So they had too much space and they were reducing their force last year. So way before any of this was hitting, and they worked out the language, but they never found that tenant. And so now they're trying to use this crisis to, you know, not pay rent and reduce the rent and all of that. And it's obvious that they were having problems before all of this started. So that's another thing to look at very carefully with your clients, is whether or not this issue has come up and the tenant had problems before this crisis.
Which kind of goes back to one of your first pieces of advice, which was document, document, document. So again, it's going to be the story, it's going to be the facts. I'm going to change gears just a little bit, just to go to a community association question, Steve. Do force majeure clauses, does it apply to condo and homeowner association contracts, like their bulk contracts, et cetera? And if so, are there any statutory considerations for a contract for a condominium here in Florida?
Yeah, obviously from the prior comment, it does apply. And to add to that comment, we really do want to make sure that not only is it reciprocal, but in some cases, we want the ability to terminate at some point. It's somewhat different than your lease situation or your construction situation, where, again, I'll go back to a cable television contract. If there was a force majeure event from the provider, the cable company has suffered some kind of an accident, act of God, they cannot provide cable television. They say you're not going to have it for the next 2 or 3 months. We say, wait a minute, that's also internet and our owners are paying for it. So we want the right to cancel the contract, and we want that right in the contract saying, I get it, 24 hours, that might be a price adjustment, but after that, it should be a cancellation, not just excusing an obligation to pay, particularly where it's a long-term contract. Again, unlike the construction contract, which may be a one-time event, and we do have the construction contracts. We have the roofing, the painting, the balcony repairs, and we're mindful of the force majeure issues there. And, you know, to Patrick's point about, you know, the shortages of materials and labor and some of those things, that's going to happen now, and we're going to be looking at those things as well. So the community associations have to be mindful of the force majeure paragraph as it will apply to them to excuse their performance, as well as the contractor's ability to assert force majeure and excuse their performance. And it becomes a protector as well. So I guess a sword and a shield, I guess, in context of a community association.
So you recommend making sure that, depending on the contract and what you're doing and the statute, that it be in there?
Yeah, and as to the statute, in particular for condominiums, there's 718.3025. It's my favorite statute, in at least favorite part of the Condominium Act when we get into contracts, because it specifies what must be in a contract for it to be valid. And all too often those form contracts that are, you know, they insist on them, whether it's an elevator maintenance contract, a security company, or somebody else, they insist on using their form contract, and it may not comply with 718.3025, which begins with the premise, to be valid, it must contain these items, including the number of people to staff it, the frequency of the services, and so forth, which may or may not be in the form contract. So do look at that statute as well. It may give you another alternative to a force majeure event.
Thank you, Steve. Patrick, we were talking about condo associations, so now I'm going to go back to construction. Are there any special considerations for construction contracts that we should be aware of or worried about in this situation?
Yes, absolutely. Most everyone knows by now that construction has been deemed an essential business operation under both the state and local executive stay-at-home orders. So this has led to an assumption by a lot of people that most construction contracts are not going to be negatively affected by COVID-19, by the pandemic. This is wrong. As I mentioned before, one of the main areas that can be negatively affected in a construction job can be supplies and the supply chain. So we're talking about steel, concrete, bricks, other finished products that go into building the road, the building, whatever structure is contemplated by the contract. So if this pandemic halts or delays for instance, the delivery of steel that's coming from China, then force majeure may come into play and may offer that contractor or subcontractor the ability to delay or even stop a project without the normal penalties that come with a construction delay. What are these penalties? The main penalty is liquidated damages. We have liquidated damages clauses in most construction contracts now. They've been upheld by courts as long as there is some reasonable relationship with the actual damages. And so a lot of times we'll see liquidated damages clauses of $500, $1,000 a day or more. So a contractor that's able to successfully use force majeure to delay the completion date of a project with no penalties is going to save a lot of money. Of course, the owner of the project now sees their project delayed. They're going to be greatly disappointed because of that delay. And for instance, if this is an office building that can't be leased, that owner is also going to lose a great deal of money. So that's specific to this area. But beyond the supply chain issues that I mentioned, you can also have a direct effect on the contractor's actual workforce. So, you know, this is what's a little different about construction as to other contracts. What happens if the job foreman falls ill and is out for treatment and then has the 14 days of self-quarantine? You can see how that could greatly delay a project. We've also seen unions that have called for strikes at some job sites because of unmet demands for safety equipment, masks, things like that. So those can also cause delays. So in the construction realm, this pandemic can greatly affect a project despite the fact that construction itself is considered an essential business. The other thing that I wanted to address is pay special attention to the fact that there is almost always a force majeure clause in a construction contract, in Florida at least. That's because of our propensity for hurricanes, tropical storms, and both of those events can wreak havoc on a construction project because it's outside and open to the weather. So force majeure is almost always addressed in a construction contract. So the very first step in looking at an issue related to force majeure is to grab the contract and see what the language says.
Good advice. Just one like housekeeping thing. We will take about 10 minutes at the end of the hour to address questions. We are getting some questions. So if you do have a question, you can send them in. We will address them towards the end. John, going to you. So we've heard about association contracts, you know, leases, real estate, construction. So I'm going to come to you, and I'm wanting to defeat a force majeure clause defense. So here's my question to you. It's simple. How can someone defeat a force majeure defense?
Okay, so it really is going to turn on whether the excuse is directly related to an impossibility to perform. So a lot of what we talked about is the payment of money. That's a hard connection to make between the event that's causing the purported excuse to perform and the remedy that the party who's obtaining self-help by breaching the contract is using as a way to excuse that non-performance. So the idea for the non-force majeure party, the idea is to look at the connection between the obligation that can't be performed based on the allegations of the party using the force majeure clause and what the contract says, given the facts. So if you have, I'll give you, for instance, there's a case that the 11th Circuit Court of Appeals decided not too long ago dealing with a force majeure clause on coal sales. There was a broker who had an obligation to provide 1.9 trillion tons of coal to a particular buyer. And in the contract, it said the primary provider for that coal will be this particular mine. And the government shut down that mine. So this broker no longer had its primary source. Presumably it had worked out a price with this primary source for what those tonnage of coal would be, and tried to use the force majeure clause to escape its liability to provide the 1.9 trillion tons of coal. Well, that didn't work because the broker can find other mines from where that broker could buy coal. The fact that it's financially disadvantaged by that shutdown is not really material to whether the performance obligation is excused by the force majeure clause. So that's an example of how you have to look at what the force majeure clause says and determine whether the performance is actually prohibited by whatever that event is.
Thank you. Anybody else want to chime in there? Okay. So, Patrick, if we're successful in ending our contract based on a force majeure clause, will the contractor or subcontractor still have liens rights?
That's a good question. Such a contractor or a subcontractor certainly may have lien rights, despite the effect or application of any force majeure clause. So by way of background, the Florida lien law, which is found at Chapter 713 Florida statutes, protects a construction contractor or subcontractor that performs work on property that improves that property or makes the value of that property higher. So if an unpaid contractor has correctly perfected his or her lien rights, they may file a lien and then foreclose that lien to force a payment of what is owed. So even if a contract is canceled by exercising rights under a force majeure clause, to the extent that a contractor has done some work that improves the property, that contractor is still going to have lien rights and is still going to be entitled to be paid for the value of that work. Now, the lien can only be for the value of the work that has been completed. So if the contractor is not able to accelerate the entire amount owed under the contract and then lien for that. If that contractor does that, then the lien can be found to be a fraudulent lien, and the contractor will be required to pay the attorney's fees of the owner that's required to hire an attorney to remove the lien from the property.
Thank you. John, what are the limits to a force majeure clause defense?
So the limits, aside from what's stated in the actual contract, the limits are going to be is going to be determined by the events that occurred and the impossibility performance. This is really, I think I've addressed most of that in my prior remarks, as has Patrick and David and Steve with respect to CA. I think the way you look at this is the limits in the force majeure clause is what the parties agreed to when they entered the contract. And then as a defendant, the impossibility of performance, the impracticability of performance, and the frustration of purpose are the other ways you could try to use these unusual, outside of the party's control type events as a way to defend against what is certainly going to be a breach of contract claim. But I think those are going to be about the limits of what you can use.
So we do have limits. This is going to be tough. So Steve, in this vein, where now we're looking at maybe we don't have a force majeure clause, or we can't use our force majeure clause. So your contract doesn't have a force majeure clause, but you can't afford to go forward with the contract. Is there any kind of insurance coverage that might defend that entity if they get sued for breach of contract? What help us out here?
Okay. If we recall back in February when COVID-19 became a part of our vocabulary, we were getting these letters from insurance companies, bulletins saying, there's no coverage, forget COVID-19 and insurance. And anytime I start seeing that, I start being very suspicious. You know, what are they trying to do? Doth thou protest too much, as they're claiming there's no coverage when perhaps there are no claims yet? So we looked at those a lot closer, and maybe there is coverage. Your typical business interruption policy that we see in community associations, and I never quite understood why a condo association would have business interruption, but now I'm seeing it a lot clearer as we experience the COVID-19 issues. It's not in the policy. 99% of the time, it's not going to say, based on a pandemic, you have business interruption, you now have coverage. Those of us who watch the president's daily briefing on the COVID-19 crisis might recall on April 14th, somebody asked him a question about this, and he indicated that he's read these policies and he agrees it's not in the policy. So President Trump said, therefore there's coverage. Well, there's a case pending in New Orleans in federal court right now where they tried that as an issue and the judge turned it down. I think that's probably the correct ruling, but the president has encouraged the insurance carriers to pay under business interruption insurance. So there's a possibility there that something may happen in that regard. There's some talk of it even being a pass-through, much like the current PPP plans for supplementing payroll so that businesses can continue to pay their employees. There may be a pass-through from the federal government funding the insurance company. So I wouldn't give up on the business interruption yet. As to the other coverage we usually see, it's casualty insurance. And again, it's not a covered peril under most policies. There's no physical damage. So you're not likely going to have it, yet somewhat perhaps unique to community associations, some, and it's a percentage of the insurance policies for community associations does provide for coverage, or at least defense, if not damages, for defending breach of contract claims. So if you do have that situation, you can't afford to pay for the contract, and you do have insurance, at least file the claim, try it as a business interruption claim. It may come in under your casualty coverage if you do have coverage for breach of contract. If not, you are left with those common law defenses and they may work for you.
Okay. Has anybody else on the panel, I know this is all new with the insurance, has anybody else had any interaction or experience with this new area of insurance?
We're looking at it, and as a matter of fact, a case was commenced in the Southern District of Florida this week, claiming coverage for a restaurant in Fort Lauderdale. So this issue is going to be a big issue, and you know we're looking at it.
So can I ask you? So restaurants are going to be typical because of the leases, and they literally have been shut down, even though they say takeout. Are they having to argue that this fits under their definition of business interruption? Does business interruption
It's the allegations in that complaint. The allegations in that complaint is that it's an all losses policy, and therefore I suspect, although the complaint was just filed, I suspect the entire defense is going to turn on the exclusion for, in that one, there's a specific form exclusion for pandemic and virus. So we'll see. There's a well-pled complaint. It's precisely the kind of allegations I was thinking about that would be necessary to make such a claim. So, you know, we're on it for our Becker clients, and we're going to keep pursuing what we can.
So bottom line is if you do have business interruption insurance, it's worth taking the policy out and getting advice as to whether or not you potentially have a claim. I mean, we know the insurance.
Absolutely.
Okay. And so along that line, John, I'm going to stick with you just a minute. What have courts done in the past with other crises that were typically, just like I think David mentioned, terrorism used to not ever be part of a force majeure clause. Most of us are old enough to remember those and see those. And then after 9/11, you started seeing that type of thing. What have courts in the past done in other crises?
Well, we actually have suffered a pandemic in the past, in 1918, the Spanish flu pandemic.
Yes, we have.
So I actually looked at, I'm a law nerd, so I went back and looked at some cases from 1920 that were dealing with appeals that related to the influenza pandemic. And they're all over the board. The issues that we've been talking about during this session are similar issues to the issues that were addressed in 1920. I specifically looked at school closure cases. So back then, teachers had specific contracts that they dealt with the school boards, and the school bus drivers had specific contracts that they dealt with the school boards. And the decisions by the courts turned on, was the school shut down by government authority? And if it was shut down, was it impossible for the teacher to perform? One school board shut down, but said, we're going to shut down for these months, but we're going to open up at the end in the summer for these additional months. So the court found that teacher had to, it was a force majeure event. The teacher had to perform in the summer months when they were going to make up the school time. The other side of the equation is the teacher, there was a case where a teacher, school was closed, and this was in another state, and the court said, once the school was closed, there's no way to make an accommodation. The school's closed. It's outside the contract. The school is excused from performing, but the teacher gets paid. So, because the school actually made the decision to close. So the decisions are all over the place back in 1918, 1920 to 1922. But it's interesting to see that the same concepts that we're talking about today were captured in the discussion then. So the ideas about impossibility, what does the order say, what is the non-performance, those are absolutely going to be critical for the courts when they address these issues, and they will be addressing these issues.
And you'll be right there, I'm sure.
I'm sure.
When they're addressed. Before we go to questions, and if we run over a few minutes, we'll try to keep it within the hour, but I do want to end with kind of an overall question that I would like the whole panel to contribute. What should we be doing going forward, either in our documents or in our areas of practice, knowing what we know and what upheaval, because I'm not sure any of us have ever lived through a government shutdown of business the way this has occurred. We've lived through hurricanes. That's 3 months at the most, you know, short-term type situations. So I'm going to start with you, David. What should we be doing going forward in case of a transactional lawyer in our documents?
Well, we've already started doing this. All of our form documents, whether it's leases, mortgages, contracts, loan documents, settlement agreements, forbearance agreements, whatever it is, wherever there's a, whether it's a force majeure clause or not, we're adding the global pandemic, epidemics, health emergencies to our forms. We've evolved, and all of your forms should add this language now. And we need to account for today's pandemic and for future pandemics. I do want to touch real quickly on one thing that John said he was discussing, that the parties limit, are limiting the language, this limiting language, and this is what we're talking about in the force majeure clause. I didn't realize it, and I guess it's subconsciously, but we've kind of, in negotiating documents in the past, the force majeure clause we kind of blow past. It's one of those standard clauses that you kind of read through in the document, you kind of blow past. It's never going to really affect you, and if it does so in a limited way. And that's the same with countless clauses towards the end of a document. What's happening today really teaches us that you can't blow past those clauses. A lot of these clauses have been written, before you started practicing law or before you got into the business, and they haven't really changed in a number of years. Well, take a look at all of your clauses and all of these boilerplate clauses in your documents, and think about how they might affect you, whether it's force majeure clause or the condemnation clause, or even the assignment of the assignment language, and tweak them. Think about what might happen if we have a crisis like this, because everything can be made, all your language and all of your documents can be made better, and it can protect your clients, and it can even help by tweaking the language, it can also help the other side, but it can be made stronger so that we don't come across something tragic like this in the future. And that's how we can be prepared for the future and make ourselves stronger and keep guys like John not working in the future. Sorry, John, but
that's okay.
I really don't like to police. I strive for the happy ending, and I don't want to have to give John business, even though it's good for all of us, but I don't want to have to give John business. I want my documents to be tight. And I really realized over the last 6 or 8 weeks that, yeah, we're all guilty of it. We haven't really looked at some of these clauses in the last 5 or 6 pages of our long documents in a long time. It's time to do that.
Any other panelists want to address that?
Yeah, I can jump in as well from the community association side. And I also litigate, so I feel John's pain here being put out of work. And that's by telling the community associations, by telling the community associations, have your contracts reviewed by your attorney. No matter what the issue is, have the attorney look at the contract. It will help you avoid dealing with me as a litigator or John as a litigator, and perhaps getting the performance that you bargained for, or being excused from the performance if the force majeure event happens to you.
Well, since I've been referenced twice, I'm going to have to chime in here. I'm not afraid that the future will be without lawsuits. I'm pretty confident that the future is riddled with lawsuits of various kinds, because as long as there are people who expectations are not met, they're going to have a fight. And as far as what COVID-19 should do for going forward, I think for all businesses, anything that has an operation, any type of conduct that they undergo as an organization, nonprofit, soup to nuts, I think you need to reevaluate your processes, how you operate, understand them, get brown paper, draw it out, understand how your business operates, and understand if bad things happen, how it's going to interfere with your operations. And then once you have that understanding, you can then make sure that you're capturing the risks associated with those types of business interference or organizational interference. You can make sure that you're capturing how to evaluate those risks when you enter into a contract or you engage in a deal. Jennifer talked about, they talk to litigators like me when they're putting deals together to try to understand where the risks are. so that people who are going to enter these contracts can evaluate the risk and make a decision. Okay, I'm willing to live with that risk. Because at the end, the way you keep me from going into court on matters is the business person understood the risk, accepted the risk, and realizes the risk was already accounted for in whatever the price was that they did. And now it's not worth it to them to fight because they've already accounted for that risk in their decision making. That's what I would propose that people start doing so that they can be better suited to deal with what this strange new world is going to look like in the next several years.
And John, that's wonderful advice. I totally agree. I think it's very important as a draftsperson to understand the risk from both your client's point of view, and to be honest, this is the best way to do it, is to go to the litigators, especially on something like a force majeure clause, and say, this is what I want to protect against. How would you tear this apart? And then we draft it from there. But I agree, the assessment and trying to think outside the box based on your business, what you need when you're going into these is extremely important. Patrick, did you want to say something? We're going to have to answer some questions here, so go ahead.
Yeah. No, I agree with everything that's been said. You know, if an issue comes up, reach out to your legal counsel and, you know, ask that question. You know, there's a saying, don't step over a nickel to pick up a dollar, or don't step over a dollar to pick up a nickel. And, you know, a lot of people, I think, hold off on calling their lawyers, asking a question about some of these problems and issues that come up because they're worried about, you know, incurring that cost. And then huge issues erupt later because of their inability to get that legal advice. So I would just say, keep your legal counsel involved in questions and issues that come up, and it'll pay off later on.
Thank you. So we're going to go to some questions, and there's been several questions along this line about prepaid services or prepaid contracts. And what's being asked is, if a customer has prepaid services or has already paid for a convention, that a vendor is excused due to the force majeure clause, does the customer have a claim to return the payments based on unjust enrichment? They're curious as to what legal theory. We have heard recently that some airline companies have been saying they don't have to refund, you know, airline tickets, et cetera, but there are a lot of contracts, you know, there's like when you've prepaid for a convention, what do you legally suggest they do to ensure that can they ensure that they get their money back, even if it says all sales are final, non-refundable, that type of language?
Who are you asking, Jennifer?
Well, who do you think?
So this is really a damages question more than it is a force majeure question. The idea is that the party who's claiming force majeure is saying that they don't have the obligation to return the money, even though they can't perform under the contract, which is kind of what I was suggesting you do with a landlord if you're a tenant like a restaurant. But in this case, it's a prepayment. And under those circumstances, if the contracting party has already performed and incurred what we call incidental damages, the cost of performing for the benefit of you, and those damages are already incurred by that party, getting a full refund is going to be more challenging. Those types of questions are very complicated and expensive inquiries, and usually are reserved for bigger disputes. And I wouldn't be surprised if you'll find class actions starting up where these decisions not to refund money are brought up in a class basis as a way to try to recover on behalf of a whole group of people where it's a small amount of money to make it efficient for recovering those damages. It's going to turn in large part on exactly what the party invoking the force majeure clause has performed when it started the contract with whoever it is that has now lost the deposit as a prepayment.
So this is sort of a follow-up on not paying rent that we had at the beginning of the session, where basically consensus was, well, you may not be able to get out of your regular rent. This is when you lose the ability to conduct your regular day-to-day business, such as an airport concessions industry. How are we able to defend ourselves legally in order to not unfairly be forced to pay minimum rents? There is an inability to conduct our day-to-day business. So they're asking how, because they've been shut down, how did they negotiate? They can't even afford their minimum rents.
All right, so the idea here is let's take, for instance, the situation where you have a bar and all it is a bar. It does not serve food, there's no takeout, nothing. It's just a bar. And the orders that have been entered in Florida shut down bars. So you have a business who can no longer conduct its business. The way to try to get the landlord to give you a concession, if you're the tenant in that situation, is to say to the landlord, you are in breach of the agreement because you're not, I can't have quiet enjoyment for the particular use that you gave me. I am precluded from it. Provided you have those facts to be able to establish that you are no longer able to use the premises, like in the case of a bar. And then the landlord is likely going to say, force majeure, I can't perform. And then as the tenant, you're going to say, well, if you can't perform, your failure to perform is an excuse for my continued performance. And that's a set off on the amount that that the landlord can't perform. I think that's probably the best way that I think you can tee up the issue. And it's going to turn on what the judge decides. And that's going to turn on what the contract says and the facts that relate to your particular business.
And the documentation that Patrick mentioned at the very beginning. So again, document. This is a real estate question that has a fairly large basis. It says the FAR bar contract, in the FAR bar contract, does the force majeure provision apply based to permit buyer to get out of the contract on either financial inability to proceed, financing had already been approved, or inability to physically attend walkthrough and closing? What are you finding, David?
Well, as soon as this crisis happened, the FAR bar promulgated a COVID-19 rider, which will deal with this specifically. On its own, there's been doubt as to whether force majeure clause alone dealt with the coronavirus crisis. So if they did not execute the new COVID-19 addendum, there's question as to whether or not you can rely on the force majeure clause alone in the standard FAR bar contract to excuse yourself from performing simply because of a force majeure event related to coronavirus. However, if you can't get financing, if that's the reason that if there's a financing contingency in the contract and you can't obtain financing and you're within the time period, then the answer is you probably can cancel the contract. Not knowing the exact dates and the time, etc., I can't answer that for sure, but typically there's a financing contingency under the FAR bar contract, and there is a time limit. So you have to look at the time limit and you have to see whether or not you're within the time limit. If the lender's excuse is we can't process your application due to coronavirus, it's not relevant to whether or not the buyer and the seller agrees or not. The lender didn't perform within the time limit. So that would be my answer right now based on what you're telling me.
So the other option is to just, if both parties agree, they amend the contract to keep it going.
Exactly. Buy yourself more time, ask for an extension as to the financing contingency, and see how long this plays out. Eventually, the lenders are going to come back around. And in fact, a lot of the lenders are coming back around and processing applications.
Okay, there's going to be two more questions and then we'll wrap it up. One goes back to associations, which we seem to be getting several of these, Steve. So if an owner that under their documents are required to pay association dues, they refuse to pay because the use of the pool, the spa, the clubhouse area are all closed. Do they have a right to say, I don't have to pay my dues?
No. And that's becoming a common question, obviously. There's no force majeure provision I've never seen in any declaration, and the declaration is a contract. It does not excuse the owner from performance. And as we're well aware, we still have an electric bill, we still have maintenance expenses, and in many of the associations, we're paying staff to do their jobs, which are all expenses in addition to the use rights of, say, the clubhouse or the swimming pool. So no, it's not an excuse. Yes, we do suggest that you be compassionate and understand people's personal situations, but do not invite non-payment or excused payment. You don't have that authority under the law, and certainly not under your documents.
Thank you. One last question. If a business hires an attorney to represent them on a claim that's been denied, and later that insurance claim gets paid, can they then ask for attorney's fees?
Well, it depends if you follow the procedures that are necessary to try to get that extra contractual right, but there are ways to try to preserve that right.
Okay. Well, I want to thank the panel. You guys have really given us some great information. I would also like to thank the audience for being here and joining us today. And hopefully you've come away with some valuable information to use in your life. And please be sure to reach out to us here at the Becker Law Firm. We're here to help. And have a great day. Stay safe out there.
Thanks, everybody.
Thank you.